Hello, and welcome to the Robert H. Jackson Center's inaugural webinar, The Age of Robert H. Jackson, London, Nuremberg, Today. My name is Kristan McMahon, and I have the privilege of serving as the president of the Robert H. Jackson Center. This program is brought to you in part by the donors to the Jackson Center and the Whitney R. Harris Lectureship Fund. We're excited to partner with our friends in London and Nuremberg today to celebrate the 75th anniversary of the signing of the London Agreement and Charter, which established the International Military Tribunal at Nuremberg. And you'll hear more about that history in a little bit. We look forward to your participation today. If you have a question for any of our panelists, please use the Q&A section at any time. We'll be collecting the questions as we go, so please don't feel like you need to wait until the end to ask what is on your mind. Today, we're going to start with Ben Ferencz, and I'm excited to bring him to you. He is the last living podium prosecutor from Nuremberg. After graduating from Harvard Law School in 1943, Ben served in an anti-aircraft battalion and in the war crimes branch of the Army, where he gathered evidence of Nazi war crimes. He was recruited for the Nuremberg war crimes trials and served as the chief prosecutor for the United States for the Einsatzgruppen case, prosecuting 22 defendants of the SS murder squads. And if you can believe it, this was his first trial. Over his long career, Ben has focused on international criminal justice and world peace, strongly supported the International Criminal Court, and tirelessly advocated to replace the rule of force with the rule of law. Ben, thank you for kicking off our program today.
Thank you very much. I'm grateful to the sponsors for remembering me and for honoring me by giving me the opportunity to simply tell you in a few minutes what I have learned in these many, many years, more than most of you, about our goals. Our goals were set clearly by Justice Jackson and by all the other members of the London Conference. We were trying to create a more humane world. I had seen the world in war. I had been a combat soldier and was awarded 5 battle stars for not having been killed at the Normandy landing, going through the Maginot Line and the Siegfried Line, and the final battle of the Bulge. My last assignment in the Army was to go into the concentration camps as they were being liberated to gather evidence which might be used in a trial against the offenders. That's an experience which has never left me. I have seen the horrors of war firsthand. No one can tell me it didn't happen. It did happen, and I saw it happening. The dead bodies all over the floor. The crematoria is still going. The inmates looking like they were more dead than alive. That certainly impressed upon me the need for me to do whatever I could to prevent that from happening again. And I've been doing it ever since. I was then, when I was a prosecutor at the Einsatzgruppen Trial that you mentioned, I accused the 22 defendants of murdering in cold blood over 1 million people, including thousands of children, shot one shot at a time because they were Jews or gypsies or other opponents of the Reich. How do you change that? That's what you are dealing with still and that I am dealing with. So let me just give you a few high points. The public doesn't want the details. They can't understand them. We have to get a slogan. My slogans were very simple. Law is better than war. Can anybody challenge that? If they do challenge it because they're too conservative, that was my supreme commander, President of the United States, General Eisenhower, who in his farewell speech said, the world cannot survive without the rule of law. If nations are to survive, they must turn to the rule of law. That has been a guiding inspiration for me. So how do you do that? A one-word answer is you do it slowly. But if you want a more detailed answer, I'm sure many of you have also written large volumes, and so have I, on how do you deal with that. But basically, what it comes down to is what I asked for in the Einsatzgruppen trial. I asked the court, I didn't ask for death penalties. And I couldn't find that it would be the scales of justice to pick out 22 high-ranking chief defenders, well-educated generals and so on, There were 3,000 criminals every day. There were mass murderers every day. To go ask for punishing these 22, there was no sense of justice to that. So I wanted to get a rule of law which would protect all human beings and entitle them to live in peace and human dignity. That was my goal then and now, because what happened there reflected the prejudices and the hatreds which existed and still exist today to different degrees. So that's the number one. Don't expect perfection. You'll never get it, but we're making progress. And we are making progress, slow progress, but some progress. Remember that if you can make progress, that's about the best that you can hope for. And we are making progress. We are going up and down periodically. The Service Members Protection Act, some of you may remember it, is being echoed again by this administration, saying the words of one of their distinguished leaders, I would say, John Bolton. There's no such thing as international law. You have no enforcement. So you have power, use it. And that's how you change your goals. That point of view should be respected, but you don't have to agree with it. And I don't agree with it. I think it's suicidal to proceed that way in the atomic age. And now we're past the atomic age. We're in cyberspace age, which means we have the capacity today to cut off the electrical grid on planet Earth. And not only do we have the capacity, the Russians have it, the Chinese have it, and I don't know who else has it. So today we are worrying about nuclear weapons because we don't know how to dispose of the waste. But the next war will finish off this planet. And there's no reason why we should be having life on the planet when there are a billion other units in the universe. And I've written a little short book on that planethood, the gist of which is you must think in planetary terms, not in national terms or individual terms. We are all inhabitants of one planet, and we should deal with the inhumans, the human residents of that planet, in a way so that everyone can live in peace and dignity, regardless of his race or creed. That was what I asked for the court in the Einsatzgruppen trial. They echoed that in their judgment. It's still a need today. So let me conclude by saying, I'm often asked, am I a pessimist or an optimist? I am not a pessimist and I'm not an optimist. I'm a realist. And a realist, I see the progress that's being made. The ball is now being passed to you. I'm 101 years old. And I've been doing this all my life and I haven't changed. Equal determination. We can and must discover how we settle our disputes without the use of armed force. That's the obliged and the UN Charter. That's what they were talking about in London, what they were hoping to achieve. And as Michael Schauf's reports will show you, people all over the world are still killing each other with armed force. How much longer can that go on? It doesn't go on much longer for me because I've had it, kids. But it's up to you, it's up to the teachers, the young students, to recognize that law is better than law. And we must substitute for the use of armed force with peaceful means only. That requires a change of heart and mind to recognize that we are all inhabitants of one small planet. And we must share the resources so that everyone can live in peace and dignity. That should be the goal of all of us. That idea is in jeopardy today more than it has been in a long time, because we have an administration which doesn't believe that anything counts except power. So it's up to the power of the public to recognize the hazards that we have, that there are peaceful solutions. We're making progress in recognizing human rights. We have to continue to make progress. That's the goal, law, not war. And if you agree with that, good luck to your kids. I'm passing the burden now on to you. May you carry the flag high. And I'm sure that in the end, we'll be further ahead toward a more humane world than we have been in the past. Best of luck to all of you.
Thank you, Ben. We look forward to having you participate in our panel in a little bit as well. To provide a historical context, we have enlisted the aid of Professor John Q. Barrett, Professor of Law at St. John's University in New York City, a board member for the Robert H. Jackson Center, and our Elizabeth S. Lenna Scholar. He is a Jackson biographer and is certainly my go-to person for any questions about Justice Jackson. John, thank you for helping us step back in time and lay the groundwork for our discussion today.
Thank you, Kristan. It's a pleasure to be with you and everyone this morning. I'm going to talk about two topics in this introductory segment. First is Robert Jackson, and second is today's 75th anniversary, the London Conference. Robert Jackson lived a relatively short life by modern standards, born in 1892, died in 1954, so only 62 years. And during the Nuremberg year, he was 53 years old, turning 54 years old. He had already by that time traveled quite a life path. He was born in northwestern Pennsylvania on a family farm. He was raised in a small town in southwestern New York State. He had completed high school in Jamestown, New York, and then become a law apprentice at age 18. He spent 1 year in a law school, Albany Law School, and after 2 apprentice years on either side of that, he became a lawyer at age 21. He was in private practice for 20 years and had a diverse practice of civil and criminal law, trial and appellate law, and corporate representation. For a couple of years, he practiced in Buffalo, New York, the big and thriving commercial capital of its region. But for most of the 20-year period, he was based in Jamestown, New York, a small city in the southern tier of New York State. In Jamestown, he had the diverse practice and he had involvements in bar associations, which connected him to the much broader legal profession. From Jamestown to Western New York to the American Bar Association nationwide, in which he rose to become a leader, chairing the American Bar Association of House of Delegates in 1932-1933. He was also elected to membership in the American Law Institute, a national elite prestigious institution, which shows something of his rise. And as early as 1924, as a bar association leader, he was part of an American delegation that traveled that summer to London for the American Bar Association annual meeting. For Jackson, that London was a bit of a heritage trip because one of his ancestors had been not a barrister or a solicitor, but a functionary, the treasurer in the Middle Temple in London. And then complexities, perhaps financial issues arose, and that man, Eldred, emigrated to the United States. In addition to law practice, Justice Jackson, or Robert Jackson at the time, had a lifelong involvement in democratic politics. It was his family's political party of allegiance, and in New York State in the 19-teens and 1920s, democracy, the Democratic Party, meant that young Jackson developed a connection with young Franklin Roosevelt. As Roosevelt's star rose, Jackson became more involved in that political career, and when Roosevelt was elected president in 1932, Jackson had an entree to service in the highest levels of national government. And so in a 7-year period in the 1930s, Jackson left Western New York and became a New Dealer. He served in the Treasury Department, where he became a national headline name, heading the successful prosecution of the former Secretary of the Treasury, Andrew W. Mellon, for tax evasion. Jackson moved from Treasury to the Department of Justice, where Supreme Court arguments became his specialty and an area in which he achieved great renown. He also was involved in litigation planning and some hard-fought trial and appellate below the Supreme Court level matters during his Justice Department years. He headed the tax division, he headed the antitrust division, then he became the Solicitor General of the United States in 1938, and in 1940 he became the Attorney General of the United States, the head of the U.S. Department of Justice, a position he held for 18 months. And a couple of features of that are notable in general terms and because of how they connect to the London Agreement and the Nuremberg process. First, Jackson was a successor to a mismanagement era in the Department of Justice, and he was focused on restoring department ethics, prosecution for merited rather than public relations or performance reasons. Jackson was also in 1940 and 1941 heavily involved in the legal dimensions of war preparatory work, as the United States was on the outside but providing aid to Great Britain and reinstituting selective service and restoring defense production and preparing, if needed, if forced, as ultimately the U.S. was, to become involved as a belligerent in the war. And that happened, of course, after Pearl Harbor and the attack on the United States. And a third dimension of Jackson's work as Attorney General was involvement in international law, because the war preparatory questions he was dealing with in 1940 and 1941 involved treaties, peace commitments nation to nation and on a multilateral level. It involved neutrality laws, it involved defense production, and it involved military assistance. Now, Robert Jackson had by this point become a leading national figure. He was a serious prospect for President of the United States in early 1940, if Franklin Roosevelt had retired, if global events had taken a different turn. But of course, Jackson never ran for office. Instead, in 1941, he was appointed to the U.S. Supreme Court. And at age 49, he began to serve as Justice Jackson and develop his enduring reputation as one of the most, I think, case at a time, non-ideological, eloquent writers, clear speakers, and leading figures of American constitutional, statutory, and judicial history. Jackson was not Chief Justice. He was only an Associate Justice, although many believed he was destined to become Chief Justice. And on that court, because of the legal path he had traveled, he was very much the first among equals. Only he and Justice Owen Roberts had been national lawyers, national figures, prosecutors. The others on that court were not leading national law figures, leading governmental figures, leading Washington figures, but not lawyers. And so the first among equals, the man for a big case, the lawyer for a client in need, is something that Robert Jackson is, and he is in the spring of 1945 when the path to Nuremberg begins. Let me turn to the London Agreement, which we're going to hear about through the rest of this program. And I want to just highlight a few elements of the London process. First and fundamentally, London, meaning legal recourse for Nazi official accountability, was a choice. The Allies had alternatives. They had vast and unlimited power and could have continued through force and through executive action, military disposition that would have been fast and summary and brutal and not observe the norms of due process. But instead, the London Agreement embodies a choice to take the path of law. Second, the credit for the London process and the path to Nuremberg, the making of that choice, if you will, belongs to the Franklin Roosevelt team. He was not living. Roosevelt died in April of 1945, but his immediate inner circle in the law-war realm, White House counsel Samuel Rosenman, Secretary of War Henry Stimson, Undersecretary Robert Patterson, Assistant Secretary John McCloy, Vice President Harry Truman, and soon to be Truman's new Secretary of State, former Supreme Court Justice James Burns, are the architects of this law choice and of the selection of Jackson, because this Allied commitment to take a law path needs the best lawyer America can get, especially going first as an incentive for the other Allied nations to similarly staff the commitment. A third dimension of the London Agreement is that it worked, and Nuremberg worked because it had global consensus. In addition to the unlimited power of victory in World War II, there was in this moment a commitment to law, to collective action, to the principles that are embodied in the London Agreement across all the powers of the globe. And thus, as an institution, it had the capital and the energy to succeed. Fourth, of course, the London Agreement paved the path to Nuremberg. The IMT Charter, annexed to the London Agreement, is the Constitution of the International Military Tribunal. It is the law of the tribunal. It bound and shaped the judges in what they were able to do at Nuremberg. It crafted the procedures that allowed the defendants to defend themselves, and they required the prosecutors to carry a burden of proof in public to persuade a court that they did not control, that they had demonstrated the guilt of the individual defendants. And so Nuremberg, of course, was a large future project ahead, but in a sense, London determined that Nuremberg would be what Nuremberg turned out to be. Another element of the London Agreement is that it was not utopian. I encourage you all to read the London Agreement and the Annex Charter of the IMT. You will see that it is a practical, doable, supported vision. It very much tracks the U.S. Bill of Rights in the way criminal process works here in the United States. Not surprising with Jackson as the engine and the leader of the London Conference, bringing this American and Anglo-American model to the international stage. And yes, it was Jackson-led. This was a four allied nation process, but the driver, the first mover, the best staffer, and the leading voice in the London Conference was Robert Jackson. He built a small but quite extraordinary team of lawyers to assist him in this phase. General William J. Donovan, head of the OSS, was Jackson's deputy in the London phase. Robert Story, a leading military lawyer at the time, was Jackson's executive counsel. Sidney Alderman, Francis Shea, Murray Bernays, James B. Donovan, the general counsel of the OSS, Benjamin Kaplan, Sidney Kaplan, Gordon Dean, William Whitney, Catherine Fite, and Telford Taylor were the lawyers, and that is the cohort of superstars who brought their brain power to bear at the London Conference. And an irony, of course, of that roster is that almost all of them were gone by the end of 1945. Only Telford Taylor remained on Jackson's staff of that first group through the entirety of the IMT process. Jackson couldn't leave early, and Taylor, of course, stayed, and not only through the IMT, but through the subsequent proceedings as Jackson's successor as chief of counsel. And finally, a dimension of London that should be noted as we commemorate it and indeed celebrate it a bit is that for Robert Jackson, it was the proudest achievement of his life. Yes, with Nuremberg, but the diplomacy and the success of the London Conference, the crafting of the charter, the drafting of the agreement, and the bringing together of the disparate allied legal systems was a crowning achievement in the realm of diplomacy, of law building, and you see this across the remainder of Jackson's life. He lived for 8 years after Nuremberg. He returned to the U.S. Supreme Court. He did very notable historical work in that domestic realm, but his extrajudicial energies were devoted to speaking, to writing, to explaining about Nuremberg. And in one particular respect, he fought hard against his own government. You see, the London Conference proceedings were transcribed by Jackson's secretary, and those shorthand notebooks were in his Supreme Court chambers thereafter. And he was determined that those proceedings would be published. And so he fought hard, and he persuaded the Secretary of State and the Department of State by 1949, 4 years after the London Conference, to pay for and publish all of the London negotiations. And so you can see the working out across the four nations, among the individual lawyers, in the many particular disputes of a rule of law that is a choice that stands up so much better than any alternative we can imagine them choosing in 1945. Thank you very much.
Thank you, John. And now I am happy to introduce our moderator for today, Michael Scharf. Michael is the Dean of Case Western Reserve University School of Law. He is also the Joseph C. Hostetler Baker and Hostetler Professor of Law and serves as the Managing Director of the Public International Law and Policy Group, a Nobel Peace Prize nominated NGO that provides pro bono legal assistance to states and governments involved in peace negotiations, drafting post-conflict constitutions, and prosecuting war criminals. Hello, Michael.
Hi. Thank you very much, Kristan.
Of course. And will you please introduce our panelists for us?
Happy to do it. So welcome to our distinguished panel about the historic importance and contemporary relevance of the signing of the London Agreement establishing the Nuremberg Tribunal 75 years ago. Our panelists are coming to you virtually from 3 virtual locations. We have David Crane, Jim Johnson, and Layla Sadat at the Robert Jackson Center in New York, and they will be focusing on Robert Jackson's appointment and the lead up to London. We have Mark Ellis and Bill Shavis in London, and they will be focusing on the negotiation and signing of the London Agreement. And then we have Navi Pillay and Klaus Rackwitz at Nuremberg, and they will be focusing on the establishment of the Nuremberg Tribunal and Robert Jackson's opening statement. I'm at Case Western Reserve University School of Law in Cleveland. This is my office. We're going to reserve time at the end of this panel for questions from the audience. What I'd like all the audience members to do is start typing in your questions in the Q&A function at any time. Don't wait till the end so that we can start asking the questions, and we're going to reserve about 15 minutes or so at the end. Let me begin by telling you a bit about these distinguished panelists. First, David Crane. He's the founding chief prosecutor of the International War Crimes Tribunal for West Africa, which is called the Special Court for Sierra Leone. He is the first American to be chosen to be a chief prosecutor of a war crimes tribunal since Justice Robert Jackson at Nuremberg in 1945. David's new book, Every Living Thing, about his time as chief prosecutor in West Africa, was published this year, and I highly recommend it. Next, James Johnson. He's the former president of the Robert Jackson Center. He is currently the director of Henry King War Crimes Research Office here at Case Western Reserve University School of Law. And in 2019, he was appointed chief prosecutor of the residual Special Court for Sierra Leone. Next, Layla Sadat. She is the James Carr Professor of International Criminal Law and director of the Whitney R. Harris World Law Institute at Washington University School of Law. She has served as special advisor to the International Criminal Court prosecutor on crimes against humanity since 2012, and she is the author of the first draft of the Convention on Crimes Against Humanity, which is being developed by the International Law Commission. Now from London, we have Dr. Mark Ellis, who is the director of the International Bar Association and chair of the UN-created advisory panel on matters related to defense counsel of the Mechanism for International Criminal Tribunals. Mark previously served as executive director of the American Bar Association's Central European and Eurasian Law Initiative, and he was the legal advisor to the Independent International Commission on Kosovo. Bill Shavis lives in London, where he is professor of international law at Middlesex University. His strong interest in the history of international criminal law can be seen in his most recent book on the 1919 Paris Peace Conference and the fruitless efforts to hold trials following the First World War. And from Nuremberg, Navi Pillay is currently judge ad hoc of the International Court of Justice in the case of Gambia versus Myanmar concerning the Rohingya people. She is also president of the Advisory Council of the Nuremberg Principles Academy and president of the International Commission Against the Death Penalty. She served formally as UN High Commissioner for Human Rights, a judge on the International Criminal Court, and the judge and president of the International Criminal Tribunal for Rwanda. And finally, we have Klaus Rackwitz, originally a judge from Germany. He was among the very first staff members who set up the International Criminal Court in 2002. For almost 9 years, Klaus was in charge of all administrative and budgetary matters of the International Criminal Court's Office of the Prosecutor. And he worked subsequently for 5 years as the administrative director of Eurojust, the European Union Agency for Criminal Justice Cooperation. In September 2016, he was appointed the director of the International Nuremberg Principals Academy. And we still have with us Ben Ferencz, who will be joining our panel and chiming in as well. So let's begin with the questions for the panel. And we'll start with Jackson's appointment and the lead up to London. So let's start by discussing Jackson's appointment. First up, to put the concept of modern international criminal law in a historic context, let's turn to David Crane. David, you have called the last century the bloody 20th century. Can you explain why you say that? All right.
Well, good morning from the United States, and everyone. It's so good to have you listening in, and to my colleagues. Best wishes on this important day, which created the beginning of seeking accountability for victims of atrocity. You know, I do call it the bloody 20th century. We don't know the exact number of human beings that died because of war and famine and atrocities, but it's well over 200 million human beings that were destroyed. And sadly, throughout the 20th century, there were over 100 million destroyed at the hands of their own government. You know, the 20th century is defined by three wars: the First World War, the Second World War, and the Cold War, a 45-year event that saw the destruction of over 90 million human beings, more than the combined casualties of World War I and World War II. You know, a terrible thread throughout all of this bloody century was there was a lack or little accountability for what strongmen were doing to their own citizens around the world, starting off with King Leopold, King of the Belgians, allegedly destroyed over 12 to 15 million human beings in the Belgian Congo. We see Joseph Stalin destroying over 34 million of his own citizens. Mao Zedong, almost 76 million of his own citizens. And of course, we see the horror of Adolf Hitler, between 7 and 10 million human beings, et cetera, et cetera. We see dictators, strongmen, and thugs throughout the Cold War destroying their own citizens and their individual states. A truly horrific event that needed dealing with. So in the middle of this bloody 20th century, we see what I call the bright and shining 4 years, which set the cornerstones to modern international criminal law. And that was, of course, the International Military Tribunal at Nuremberg, which we celebrate the London Charter today, the 75th anniversary. But we also see the establishment of the United Nations, the cornerstone of international peace and security, even to this day. And of course, we saw the creation in 1948 of, I think, one of the more important documents in human history, certainly legal history, and that is the Universal Declaration of Human Rights, which for the first time under law established the right of human beings to exist. And so in modern international criminal law, and obviously to this day, we see the fact that if a thug, a dictator, or any entity destroys human life, it gives us the ability to seek justice for them. Of course, then we also see the Genocide Convention of 1949 and the Geneva Conventions of 1949. Without these principles laid out in these various documents, it would have been very, very difficult in 1993 to begin working on the age of accountability. You know, only in the 1990s, through this bloody 20th century, we see again the establishment of two ad hoc tribunals for Yugoslavia and Rwanda, and then the beginning of a wonderful idea, a permanent international criminal court in Rome towards the end of that bloody 20th century, and then very, very shortly afterwards, the creation of the tribunal in Sierra Leone. But again, it's important for us to reflect today that the cornerstone document by which we began what we now call the age of accountability today is the London Charter that created the International Military Tribunal at Nuremberg. Back to you, Michael.
So Dave, thank you for walking us through that progression. The United States has not always been a big supporter of international justice. Leila Sadat, why was the United States willing to consider an international tribunal after World War II, given its resistance to trying Kaiser Wilhelm after World War I?
Thank you so much, Michael, for the question, and thank you, everybody. It's really a pleasure to be here. Well, I'll just pick up on what David said. World War II was the deadliest military conflict in history. There were an estimated 70 to 85 million people who perished, about 3% of the world's population. And US military casualties alone are estimated to be over 1 million. And you only need to visit the American cemeteries in Europe to understand the toll that the war took. Not just in World War II, but of course, you see gravestones from World War I. And while it's true, Michael, as you said, that the United States had objected to the trial of the Kaiser after World War I, arguing that a head of state was only responsible to his or her own people, not to this vague idea of the international community. There had been many plans that nonetheless surfaced after that were put forward by the International Law Association and later the London Advisory Committee. And so the idea of this of international crimes being tried by an international tribunal was floating out there, and lawyers in the United States were certainly aware of it. Following the D-Day invasion of June 6, 1944, we saw sort of I didn't get to hear Professor Barrett's intervention, so I'm not sure what he said, but there was a split really in the United States with Henry Morgenthau, who was the Treasury Secretary, putting forth a plan for essentially deindustrializing Germany and summarily executing captured Nazis, whereas Stimson and Cordell Hull, that is the State Department and the Secretary of War, put this memorandum calling for war crimes trials. The rest, as they say, is history. While we understand that Roosevelt was very tempted by the Morgenthau plan and at one point floated it at a meeting in Quebec in September of 1945. Subsequently, we did see that the Stimson-Cordell-Hull plan prevailed and war crimes trials were to be the way of the future.
Well, Leila, Roosevelt dies in April of 1945. Truman takes over. What was Truman's role in the establishment of the Nuremberg Tribunal?
So it's very interesting because Roosevelt is really he's considered one of our greatest presidents. He's this iconic figure. And so most people, when they think of the Second World War, think of Roosevelt, but of course it was Truman that had to finish the job. He was a country lawyer from Missouri. I'm in Missouri right now, as you can see. He unexpectedly became president when Roosevelt died. He was actually a big fan of the trials. He was a big fan of Robert Jackson. He was a big fan of the notion of the trials. And subsequently, if you go to his library, and it's here in Independence, Missouri, you can see that he really embraced the Nuremberg trials as a terrific solution to the problem. That doesn't mean he was not necessarily a controversial figure, right? He also was responsible for the 2 atomic bombings that were unleashed on the world as a way of settling the conflict in the Far East. But he was a fan of the trials. He wrote often to individuals. I found a letter he wrote to Willis Smith in 1946, the head of the American Bar Association, that he thought Jackson was doing a remarkable job over there, meaning in Nuremberg. And he said, I believe the effort will be very, very great on future wars. At least I hope it will help to prevent them. So Truman was quite a fan.
So, and Leila, Truman was the president that then selected Robert Jackson. Why was Jackson the best right choice for the U.S. chief prosecutor and negotiator for the Nuremberg trials?
You know, Jackson Jackson had incredibly impressive credentials, right? He was a Supreme Court justice. He had previously served as U.S. Solicitor General and Attorney General, the only person in history to hold all three of those positions. Like Truman, which is interesting, he was born in upstate New York. He was born a country lawyer. He had only a modest education. He read for the bar. I try not to tell my students that because they have to pay for 3 years of expensive legal education. He's known as being one of the best writers on the United States Supreme Court, and the soaring text of his opening address at Nuremberg really bear witness to that. A lot of people make much about his difficulty with cross-examination with Goering. I think that critique is probably overblown. It was one of those moments that just didn't go as well as some of the other moments, but he was an extraordinarily gifted lawyer in every other way: intellectual brilliance, managerial skill, and the ability to craft soaring texts. And he had much in common with the president, which obviously helped get support from the United States administration for the trials. Later, they had a little bit of a falling out because Jackson wanted to be Chief Justice of the United States Supreme Court, and he wasn't named Chief Justice. So
let's turn to Jim Johnson. Jim, Robert Jackson reported to President Truman that one of the most important legacies of the Nuremberg trials was that they documented the Nazi atrocities, this is the quote, with such authenticity and in such detail that there can be no responsible denial of these crimes in the future, and no tradition of martyrdom of the Nazi leaders can arise among informed people. Now, Jim, do you believe that international trials from Nuremberg to the Yugoslavia Tribunal, the Rwanda Tribunal, the Special Court for Sierra Leone, the Cambodia Tribunal, the Lebanon Tribunal, and the International Criminal Court, and many that I'm leaving out, do you believe that those trials are successful at playing this educative function that Robert Jackson mapped out?
Well, thank you, Michael, and it's a pleasure to be here. And as you see over my right shoulder, I'm coming from Jamestown, New York, outside the Robert H. Jackson Center. But let me say this: yes, I very much believe that they do, but to the extent that facts are litigated, adjudicated, and decided in the tribunals today. The Nuremberg did a relatively comprehensive job of being able to document the atrocities coming out of World War II. Today's modern international tribunals are neither mandated or, for that matter, resourced to build such a complete record of the atrocities coming out of their conflicts as Nuremberg was able to do. A prosecutor today has to be much more selective in the charges they bring, the crime bases they bring, and to the extent that they bring those charges and adjudicate those crime bases, they very much do document the atrocities that took place. But today's trials are long, they're expensive, and a prosecutor has to be very selective in what they charge. In the months before Charles Taylor came into our custody in Sierra Leone, we took a good hard look at the initial indictment that we had brought against Charles Taylor. And we consolidated that indictment. We reduced the number of crime bases that we had charged in that indictment. We took a good hard look at the charges and the offenses that we had brought in order to reduce the amount of time it would take to try that case. And so, unfortunately, prosecutors today, by the very nature of what's happening today, they have to be selective in the charges they bring, in the crime bases that they prove. And so, to the extent that they do that, yes, they do meet that educative function. But tribunals today are not in a position to create the complete historical record of crimes that took place in a conflict like they were able to do in Nuremberg.
Jim, let me ask you a follow-up. In Robert Jackson's reports to President Truman after the Nuremberg trial, he said, quote, "Many mistakes have been made and many inadequacies must be confessed. But I am consoled by the fact that in proceedings of this novelty errors and missteps may also be instructive to the future. So Jim, in what ways did the modern tribunals learn from the mistakes of Nuremberg?
Well, you know, and of course, when Robert H. Jackson made that statement in 1946, he could only hope what his work out of Nuremberg would have brought in the future. And I'm not so sure that his concerns truly were realized as to the mistakes that were made in Nuremberg. But certainly the international tribunals, the modern international tribunals, have tried to build on that. Some of the concerns that came out of Nuremberg were certainly and will never be overcome to some respect, in that Nuremberg was victor's justice. You look at Nuremberg was tried by the 4 victorious powers and the other states, 19 other countries, of course, coming in. But can you say that was truly an international tribunal? The only people standing in the dock at Nuremberg were, of course, Nazis, were, of course, Germans. None of the other, no one else from the victorious powers were tried. The international, you can certainly say by the modern tribunals that were created by the international community, created by the United Nations, that these truly were international tribunals and truly were looking at all parties to a conflict. And so that was just a test of time. Another concern coming out of Nuremberg was the retroactive nature of the charges. And that was continuously a concern by many, that these charges, that many of these were not crimes, that crimes against peace, against humanity, were new crimes and could not be charged at Nuremberg. Of course, again, the test of time has fixed that. You're now 40 years later, the new tribunals, there is no doubt that these are indeed crimes under international law. We went through the same thing in Sierra Leone, where we were the first tribunal to charge child soldiers. And the same review had to take place. In other words, were we charging this retroactively? And again, our appeals chamber looked at many of the same issues to determine that child soldiers were indeed a crime at the time we've charged it. Other concerns, just from a practical standpoint, I think they've learned from Nuremberg. You indeed now have an independent registry that is there to oversee the trials, to bring together the judges. Judges are truly international, appointed by an international body and come from everywhere. You have right to counsel guarantees of the accused that have been expanded upon in the modern international tribunals. You have, just to name a few, in Nuremberg, you had, there was no right to appeal. And the verdict of the IMT was final. And of course, you have a right to appeal at the modern international tribunals. Nuremberg did not specifically guarantee that you were innocent and proven guilty. And of course, that has come into the modern international tribunals. So there are a number of areas that we've learned on from Nuremberg and tried to bring those lessons forward.
We certainly have come a long way. Let me finish this segment by going back to David Crane. Dave, you have described the evolution of atrocity accountability by using the metaphor of waves crashing against the rocks of impunity. You've written extensively on this. Could you describe what you call the first wave, the second wave, and now today, the third wave?
I'll be glad to, and it's very interesting listening to the historical context of all of this and how far you truly have come in order to seek fair trials, open trials for those accused of mankind's worst crimes. The first wave was the International Military Tribunal at Nuremberg, mankind's first effort to, in some ways, not perfectly, but in some ways, use the law as opposed to the gun in order to close out and seek justice for victims of atrocity. Huge step, a beginning, but a huge step. The second wave began in 1993, and that was where we see the advent of the creation of the 2 ad hoc tribunals in Rwanda and Yugoslavia, and then of course the first international hybrid tribunal for Sierra Leone, and then of course the permanent court in The Hague, the International Criminal Court. And of course we have ancillary and important trials going on during this time frame at all. I call this the age of accountability. And it began around 1993 and sadly began to diminish and fade away around 2015, 2016 in this amazing geopolitical event that I never saw coming, having been in public service for almost 40 years, and that is a rise of nationalism and populism, not seen since the late 1920s and early 30s. I could almost hear jackboots over my shoulder. And the world turned inward and stepped away from the hard work that many of us on this call today worked so hard to create, and that was the age of accountability. So after 25 years, we see a retrenchment slightly, and it's some of it's circumstantial. And this is the beginning of the third wave, which I call the age of the strong man. You know, the major tribunals, Sierra Leone, Rwanda, Yugoslavia, finished their work about the same time this nationalistic approach to the world began. And so the third wave, and I think it's very important for all our listeners to understand, is that we're still continuing to fight despite the challenges of the ICC and the fact that we don't have any more valid tribunals around doing their work other than Lebanon and Cambodia. But we see the rise of grassroots efforts of seeking justice. We see domestic states, states parties prosecuting war crimes acceptable under their domestic law. We see, again, the important aspect of how NGOs have stepped in and taken their expertise and continued building criminal dossiers. So the fight is still continuing, but it's a cautionary tale, isn't it? We've seen the bloody 20th century. We see all of the amazing things started at Nuremberg through the age of accountability. And we thought that this was the beginning of a time where we would, in fact, standardize substantively atrocity accountability. And guess what? Here we are today, and we're reeling under the heavy weight of strong men around the world questioning just the very value of the rule of law in the international community.
So as you say, Dave, the fight is still continuing, but it may be the battlefield that has changed. Let's turn now to the negotiations of the London Agreement with our experts that are virtually, at least, in London. And that's Mark Ellis and Bill Chavis. So with the London Agreement, the creation of the International Military Tribunal was assured. However, many people are unaware that the United Nations War Crimes Commission was an important precursor to the Nuremberg Tribunal. So let's turn to Mark Ellis. Mark, can you tell us how the UN War Crimes Commission came into existence and how it's relevant to the London Agreement?
Yeah, Michael, thank you. And thank you. It's a delight to be here with everyone. You know, I see international justice as a journey. I think it's been alluded to so far this morning. For me, it's an arc of progression in that there are kind of pivotal moments in this journey. And in 1941, Churchill and Roosevelt met and they really said, we have to do something to create an accountability for Nazi war criminals. And this then led to the St. James Declaration and the Moscow Declaration that established this United Nations War Crimes Commission. Of course, the United Nations was not created at that time, but it was called that. It was established by 17 allied nations, and of course, headquartered here in London, which when they established it, the purpose was really to create an opportunity, an avenue, so that members of the Nazi parties who were responsible for these atrocities would then be sent to countries where the crimes were committed, and they would be tried by the allied nations. And so this commission here in London, it was just an advisory body, but a very important one. It classified the crimes, it provided legal recommendations to the allied nations, but it had no executive powers. It didn't have really a heavy staff. responsibility to apprehend and to try these individuals was rested with the nation states. So in many ways, we can see the commission as a precursor to the principle of complementarity that's enshrined in the Rome Statute, giving nations really the primary jurisdiction. And so that was really fascinating to see that. But the collaboration between the commission, and particularly with Jackson, and as Nuremberg Charter began, as the trials began, the commission had always recognized that the Allied nations could not and were in no position to try high-level perpetrators, that there needed to be some type of international court. And the Hearst, who was the chair of the commission, referred to this as the need to try these major war criminals through an inter-allied court. And when that happened, when Nuremberg came to be, the collaboration between the commission and Jackson was really quite important. Jackson writes about it. He attended meetings of the commission. The commission was really focused and felt that it was very important for its staff to assist Jackson. The chairman of the commission was absolutely adamant that all the resources, all the collaboration regarding evidence, regarding documents would be shared with Jackson. And so in hindsight, I think you can see that the commission played a very important role, certainly in the international discussion of accountability, but also I think it influenced Jackson. And so again, this arc, those that came before and after the London Agreement were all connected in very important ways. And this certainly was the case with this War Crimes Commission.
Yeah, and Mark, this is a pattern I think we've seen in the modern tribunals. There was the Yugoslavia Commission created by the Security Council that led to the Yugoslavia Tribunal, the Rwanda Commission that led to the Rwanda Tribunal. In modern times, we have the IIIM that is trying to prepare cases for possible domestic or maybe international prosecutions in Syria, and the IIMM that is doing the same for Myanmar. Now, let me go to Bill Shavis. Bill, the London conference followed a debate that Layla Sadat referenced about whether to hold the trials at all. In the alternative, there was support among the leaders for some form of summary execution. In fact, I think the debate was, should there be massive hangings or a firing squad? Bill, do you think there was ever any real doubt that there would be an international trial?
Thank you, Michael. And I wish you were here with me in London on this. It's a very hot afternoon in London. The temperature is more than 30 degrees. I won't translate that into American. I think you know that that's a hot day. I take my students for a walk around London and show them where some of these events took place, the London Conference, the UN War Crimes Commission. Mark has described the UN War Crimes Commission, and he's explained that it was a consequence of what was called the Moscow Agreement at I think the 1st of November 1943. And it reserved the prosecution, or it didn't even say prosecution, it said that the Allies reserved the right to determine later how they would deal with the major war criminals. The British went away from that with a plan for summary execution. They didn't want to have trials at all. And I found in the British archives in London files on all of this where they actually had bureaucrats in the Foreign Office preparing hit lists, because the British military said to the government, you know, you can't just tell us to go around executing people. That's not our job description. So if you think we have to summarily execute people, you're going to have to give us the list and tell us who they are. And the British stuck with this until April of 1945, when they finally gave it happened at San Francisco, one of the very earliest sessions in May, actually, of the San Francisco conference. Something that's always intrigued me about Jackson is that he included in his book that he produced afterwards, his report to the president, he included the British memo to the Americans, the aide-memoire, where it was their last gasp at fighting for the idea of of summary execution. They didn't want to have the trial. And so they gave in, thanks to Roosevelt, thanks to Truman, thanks to Stalin, they gave in on that. And I saw that someone has asked a question, maybe I can even answer it already, has asked, was it difficult to convince the French and the Soviets to do the trial? Not at all. The difficulty was the British, of all people. So I think that although the British resisted it, and I think it was Churchill himself who didn't want to have a trial, that in some ways it was the tide of history that made it inevitable because of what had happened in 1919, because of the UN War Crimes Commission, because of all the interwar work, because of other bodies like the London International Assembly. It was just unthinkable that they wouldn't have a trial, I think. And finally, they had to call Churchill on this, and he caved in.
You know, when critics look back at Nuremberg and are often critical of the many things that Jim Johnson was describing and how far we've come since then, they sometimes forget that the alternative to the Nuremberg trial was literally a firing squad, and that Nuremberg was this great experiment. And of course, you know, it wasn't going to be perfect, but if you look at it through the historic lens of history, it was a lot better for the Nazis than the alternative. Let's bring in Ben Ferencz. Ben, are you out there still? Can you hear us? My friend Ben, are you still with us out there? I was hoping to ask Ben this question. Robert Jackson remarked that the most important legacy of the Nuremberg Charter was that it outlawed war. And I know that Ben has devoted his entire career to trying to make that the legacy that exists today. Ben, are you there?
Yes, I think I'm on. Can you hear me now?
Yes, Ben, I was going to ask you about the legacy of the Nuremberg Charter in outlawing war. Can you comment on that?
Well, I'm overwhelmed by the question because we have not outlawed war. War is as popular today as it ever was, except its impact is liable to be the last impact. So Jackson recognized that the crime of aggression was a crime which should be a supreme international crime. And the hope was that the Nuremberg trials would so condemn it that it would not be considered in the future. Well, it didn't work out that way. They refused to define aggression. They still have not defined it adequately, in my opinion, because they have rights of people not accepting it or stepping away from it. And so the key there was who decides who is the aggressor. And that's a problem which has not yet been resolved. I approach it personally. I think we have to eliminate the use of armed force. That's the crime, the use of armed force, because it's too dangerous today. We'll kill everybody if we don't change our way of thinking, which requires a change of heart and mind, a willingness to compromise, a willingness to be more tolerant to other people's point of view, all of which we are in the process of building up. And I think we're making considerable progress through the new tribunals, which have been described here, and also with the growth of the idea of human rights being an entitlement, which is taught in most of your universities. So we're making progress, but to say that we've given up lawmaking, as Eisenhower himself had recommended, we still got a long way to go, kids.
You know, and Ben, even though we do have a long way to go, we've made a lot of progress, thanks largely to your efforts. In 2010, a definition of aggression was adopted at the Kampala conference by the Assembly of States to the International Criminal Court. Can I ask Mark Ellis, why is this concept still so controversial? Mark, you still with us?
Michael, thank you. Sorry. You know, as you alluded to, I think the Kampala Review Conference really was important because I think in many ways it kind of finished the work of the Nuremberg trials and the charter, particularly in regards to the the definition of a crime, even though Ben is right. I think there's some issues with that. But this too is, I think, part of this arc of international justice that I talked about earlier. And even before Nuremberg, as has already been alluded, Bill Chavez has written that remarkable book talking about the attempting to try the Kaiser after World War I. Layla alluded to this as well. And this too, so you started the Paris Peace Conference and great significant debates about the existence of crimes of aggression. Some were adamant that the crimes had crystallized in law, others were not. And so it continues. And even in this, even when I referred to the United Nations War Crimes Commission, that too had this same type of debate. And so it continues. And today, for me at least, it remains rather political. And this to me is where we really are kind of facing a situation where you're saying, well, can you have a provision when in fact it requires just the state parties to agree to it, and if they don't agree to it, then if they haven't ratified the agreement, then they do not have to abide by it. And so this is a political compromise. But in practice, I think this is a fairly significant difference, because what you do is you have only 35 state parties so far have ratified the amendments, and that's not even to talk about the non-state parties. And so it was easier in Nuremberg to embrace this concept of crime of aggression because it was pushed by an occupying forces. Today, we have to have a buy-in. And that buy-in is very important, and we simply don't have the buy-in. And so I think this is going to continue to be a really challenging time for the international community to get to a point that Ben Ferencz refers to as really being able to outlaw war. So a progression, yes, in this arc, but still great challenges ahead in regards to this particular crime.
So let's move from the substance of the Nuremberg Charter to the procedure. And I'll get back to Bill Chavez here. Bill, the London Conference involved many compromises by each of the four powers that participated. In terms of procedure, a hybrid system emerged with elements taken from the different legal traditions, common law, civil law, whatever the Soviet system could be described as. Looking forward from London and Nuremberg, did this help in developing a genuinely international criminal procedure, or did it merely foreshadow future battles?
Well, thank you. You know, Michael, a few weeks ago, I attended a social event in Paris for one of the candidate judges for the International Criminal Court. And in the middle of our conversation, a French academic started in saying that the job of the new judges would be to reform the procedure at the International Criminal Court and to make sure that the French or a French-inspired system prevailed at the International Criminal Court. I can't get over the fact that this battle is still being waged. It's a battle that all those who've worked in international criminal tribunals have seen. And I have looked back at Nuremberg and been struck by how, although they had difficulties trying to sort out the procedure, because no one had ever done this before. And Jackson didn't understand the French system, and he didn't understand the Soviet system, and the British and the Russians and the French didn't understand the British and American systems. They worked it out. There was this remarkable spirit of cooperation. They were trying to find a solution, and they solved the problems. So it wasn't, my reading of the transcripts is that it wasn't an antagonistic environment. There was a lot of oxygen in that room in London, and there was a will to get the job done. I find that in our more recent tribunals, there's a lot of pettiness about it. It's clear that international justice has to have, and the tribunals, they have differences in their procedure, and that's inevitable. Well, I don't know whether the Nuremberg Tribunal helped that. they certainly got the job done. And they did it in a fair way. You know, I listened, I was starting to get a bit agitated when I heard Jim going through his litany of all of the shortcomings of the Nuremberg trial, because, you know, deep down it was a great trial. I'm convinced it was a great trial. You know, Jackson pointed out things like that people overlook, that the defense evidence took almost twice as long in the trial as the prosecution evidence. The German lawyers came into the court when it started thinking that this was a bit of a kangaroo court. And after a couple of weeks, 2, 3, 4 weeks, they realized that they actually had a shot at it. And as Robert Jackson pointed out, of the 22 who were actually, or 21 who were actually on trial, all but 6 of them had some of their charges dismissed, and 3 of them, as we know, were acquitted. So I think it actually stood up rather well. And I would, you know, I mean, I think Jim's points are all good and they're valid, but I would hate the audience to be left with the impression that this was somehow a shabby operation. It wasn't. It was a great trial.
Yeah, and the fact, as you described it, that they were able to blend these different systems is really nothing short of miraculous. In the International Criminal Court, there are people who believe that there are times when there is literally a Darwinian struggle going on between the judges who are trying to apply in the ambiguous aspects of the tribunal statute, common law versus civil law concepts. And so that struggle goes on today, and in some ways it was handled better by the judges at Nuremberg and the negotiators. So Mark Ellis, you personally and the International Bar Association have been deeply engaged in universal jurisdiction prosecutions around the world. For years, academics have debated whether Nuremberg represented universal jurisdiction or territorial jurisdiction derived as an occupying powers had jurisdiction over the territory of Germany. Do you think Nuremberg laid the foundation for the extension of universal jurisdiction from piracy to crimes against humanity in modern times? And what's the importance of that?
Well, I certainly think Jackson thought so. You know, he spoke passionately. This gets back to Leila's point. I mean, he was a passionate person who spoke passionately about enforcing right and wrong. And so I think you can look at the court's work as I think implicit, as an implicit endorsement of this universal jurisdiction concept. And I think it will be a legacy. It is a legacy, I think, of the court's work. It's controversial. Michael, I think you're on the side, many things you've written suggesting that the court did set that foundation. I think you're right. I think it had a critical influence on at least the customary law development of universal jurisdiction. And many people see it, universal jurisdiction, as being quite exotic, but it's been around for centuries. You alluded to the piracy on the high seas. The concept was widely used after World War II. And of course, the most famous case was the Eichmann case. That was the most prominent in regards to universal jurisdiction. But I think today that the principle of universal jurisdiction, at least through customary international law, is here. It extends to the most serious, I think, human rights violations. But I think there is a concern. Where do we go from here? The concept that came out of Nuremberg in post-World War II struck a note focused on absolute universal jurisdiction. So the idea that the jurisdiction was based solely on the nature of the crime. It didn't matter where the crime was, it took place, didn't matter the nationality of the accused or the connection with the state bringing to justice an individual. The trend, though, I think now is moving to a much more restrictive interpretation of the application of universal jurisdiction. And it comes through this kind of conditional universal jurisdiction. So you're allowing jurisdiction through, but only if there's some degree of nexus between the crime and the forum state, whether it's the victim or the accused needs to be a citizen, a number of restrictions. So that's the real issue. Is the pendulum shift in this more restrictive use of universal jurisdiction, is it permanent? because if it is, it does alter the more aggressive form of universal jurisdiction.
And it might be the case that the events in Syria and the number of Syrian refugees who were victims and also some who were perpetrators that have ended up in Europe is starting that pendulum shift again toward a more aggressive form of universal jurisdiction that we're seeing in the courts of Germany and in France and in other European countries.
Let's hope so.
Let me turn to Bill Chavis. We were talking a few minutes ago about the UN War Crimes Commission, and it had been meeting, since 1944, as has been pointed out. One of the things it had proposed was the creation of a permanent international criminal court, a permanent Nuremberg. But that idea was rejected by the British and the American governments in favor of this temporary one-time military tribunal, and I suppose the follow-up Control Council Law number 10 courts as well. Bill, do you believe that that was a missed opportunity to create an international criminal court 50 years before the Rome Conference got around to doing it?
Lots of marvelous things happened in the, I guess you'd call it a Grotian moment, as you have. I think you took the term from Richard Falk, didn't you?
Yes.
And a turning point in international law and international legal development. Could they have created a permanent court? Who knows? I don't know. I know that the War Crimes Commission prepared a draft, very nice statute. It would have done the job. They sent it to Anthony Eden, the British Foreign Secretary, where it sat on his desk for about 4 months. And then he finally deemed to reply just saying, we're not interested. Of course, they couldn't have known the plan Eden had with Churchill, some variation. Later, when they decided to go ahead, they made it clear that it would be a military tribunal. And I think we have difficulty today understanding that term. I mean, it was an executive type of decision by the four powers, although it was subsequently endorsed by others, to create a military tribunal. Really, today we just call it an ad hoc tribunal. There wasn't much military about it, finally. And, when people hear military justice, we think of Clemenceau's famous saying that military justice is to justice what military music is to music. But it wasn't that. There's some reference, I think, in one of the very, very first decisions of the Yugoslavia Tribunal, even before the Tadic Appeals Chamber decision, that said something pejorative about the Nuremberg trial, about how it was a military tribunal, suggesting that it delivered summary justice, but it didn't. But think of it, as a comparison between the ad hoc tribunals, the temporary tribunals, with a focus on one situation, and the ICC. And we can see it's just, they're two different animals. They're one, look at the Yugoslavia Tribunal. Within 6 years of the statute being adopted, you had Tadic tried, appealed, convicted, done, dusted. At the ICC, it took 12, 13 years from the adoption of the statute to finish one trial. It's just, there's something harder about it. And I don't think it would have been any easier in 1945. Certainly they wouldn't have finished the way Nuremberg did Nuremberg from the 8th of August, 1945, it was done by October of 1946. Astounding. We can't do that today.
And there was something about the timing that enabled the world to move on from World War II that may not have been the case if it had dragged on 10, 15, or even 20 years, like the cases before the International Criminal Court. Let me ask the last question of this segment to Mark Ellis. This summer, the international community is also remembering 25 years since the massacre of Srebrenica. The event remains divisive, with many Serb leaders still calling it fabricated, a myth. Mark, what does it say about the aspirational goals of the London Agreement that 75 years on, atrocity crimes are still the norm?
Yeah, again, Michael, this, I think, is still about this arc. We're sitting here 75 years on from the London Agreement. I decided to wear my Union Jack vest in
Love it.
in celebration of that. But the reality is we all need to ask ourselves, have those aspirational goals been met, those great goals of 75 years ago? Because when you look at what's come since then, international criminal law, I've always felt, is deeply rooted in moral sensibilities, in moralistic language that's used. So Nuremberg Trial, the words, the crimes that shook the conscience of humanity, the ad hoc tribunals that we've talked about, Yugoslavia, Rwanda, they talk about restoring and maintaining peace, national reconciliation, stability, ICC about ending unimaginable atrocities. This is very powerful language. And I think all of these tribunals, from Nuremberg to the most recent ones, are premised on these aspirational goals of bringing about a better world through justice. Jim talked about documentation issues. There's been successes, but the institutional kind of that was established 75 years ago set a really high bar. And David Crane, Layla both referred to the 20th century, and our good friend Sharif Bassioni, who I think all of us wish were here, did this remarkable pioneering study. David alluded to it, where he was saying, the 20th century will be remembered for the 200 million innocent civilians that were killed in war, civil strife. Bill just alluded to the issues of the expectations of the ICC, what they've accomplished, what they haven't accomplished. And I think many feel that the ICC has fallen short of the expectations. And finally, I think for me, we have to remember that international justice is not always equitable. The powerful often escape accountability, the powerless cannot. And so if we're talking about a third wave that David Crane alluded to, I think it's for the younger generation who I hope is listening, because they have to pick up the mantle to ensure that international justice is sustained. And it's not, for me, about just accountability for the perpetrators of these crimes. For me, most importantly, it's about being a voice for the victims. And this is a responsibility for all of us, but particularly for the next generation. And I hope then we can say we've succeeded.
That's a great bridge to our final segment. Let's now focus on the establishment of the Nuremberg Tribunal, Jackson's famous opening statement, and the legacy. And we're going to bring in Navi Pillay and Klaus Rackwitz, who are virtually in Nuremberg with us. Let's start with Navi. Navi, Justice Jackson's opening statement at Nuremberg has been hailed today as one of the best examples of effective rhetoric in history. Let me ask you a couple of questions about his most famous quotes, and one that has been attributed to him that he didn't actually say in his opening. Let's start with when Jackson tells the Nuremberg Tribunal, quote, "Unfortunately, the nature of these crimes is such that both prosecution and judgment must be by the victor nations over the vanquished foes. The worldwide scope of the aggressions carried out by these men has left but few real neutrals. Either the victors must judge the vanquished, or we must leave the defeated to judge themselves. After the First World War, we learned the futility of the later course, and that was the end of the quote." So, Navi, victor's justice, it wasn't just a problem for the Nuremberg Tribunal. In the Milosevic case, a UK judge was one of the 3 to try the former Serb leader just a few years after the UK had joined the NATO intervention bombing campaign against Serbia. How has the International Criminal Court sought to avoid the problem of victor's justice that Jackson was describing?
Well, thank you for your question, Michael. And of course, as a judge myself, both in South Africa, the Rwanda Tribunal and the International Criminal Court, there is a priority consideration for us, which is impartial and independent dispensation of justice, which is what Jackson was alluding to about victor justice here. But why did Jackson say, unfortunately? And I think if he were alive, he would scream that word out today because of the domination of these same nations, to whom they added the fifth nation, China, purely because they match the economic power of the others. So the prosecution and judgment of other states is still dominated by these victor nations. And I think that's what's so unfortunate, that Robert Jackson had the forethought to think of it then. What we're seeing, for instance, that by wielding the power of the veto, 3 of these P5 states who do not belong to the International Criminal Court, in fact, do not support international criminal justice, have the power to escape justice. They can use the veto to prevent a scrutiny of their own actions, and yet they have the power of referral and deferral of other states. And besides that, what is their claim to be sitting in judgment over others? The claim is that they are the wealthiest, most powerful, and dominate the military might. And this are opposing factors to the rule of law. And I'm mentioning this because, you know, these states follow their own geopolitical agendas, as we know, and they have blocked resolutions that call for investigation of atrocity crimes. So many people have voiced their concern about these acts of double standards and the pursuit of geopolitical agendas as detrimental to building trust in international justice institutions, and that they are an impediment to the struggle against impunity. So I just wanted to say that because there's so much visionary thought in that one word, unfortunately. So of course, serving as a judge on the ICC, I see how carefully all the states got together. So it was an effort by the international community, not victor states, to get together and draw up this statute. The first principle is they established a legal system that binds the whole world. So we have the Rome Statute. It's true, it's not universal as yet because only 124 states have ratified it. Now, in my capacity as the president of the Council of the Nuremberg Principles Academy, the Academy wants to promote the Nuremberg Principles, which were expounded, pulled out of the Nuremberg Trials. And, you know, twice a year we sit in courtroom 600 in Nuremberg, and many of the distinguished panelists today have joined us in discussions in courtroom 600 on how best to get a convention, a treaty adopted, where all states will subscribe to the Nuremberg Principles. And if only we can get the Security Council to adopt that, it will be a way of getting Security Council reform, I think. But back to the ICC, we already heard some of the measures for fair trial procedures. Well, the ICC has provisions for defense counsel, and if accused cannot afford that, that's provided for them. The judges and prosecutors go through a selection process. They are elected by all the parties to the Rome Statute. They could come from the so-called vanquished state as well. They're not dominated by men, which would have happened if they didn't put in the clause about having a requisite number of women judges. And most importantly, they provide participation and reparation for victims. Now, there are many provisions there that provide the checks and balances. It is the 21st century. We cannot follow the Nuremberg standards of due process. Unfortunately, the judicial process is long because the more thorough it is, the longer it takes. You have to we judges, for instance, had to ensure that everybody gets their equal time in court to present their views. So that's why trials are taking much longer. So I think many of these problems about victor justice have disappeared because of the structure of the ICC. Nevertheless, as we all know, Africa complains because all the indictments issued so far, they say target Africa. So they're very unhappy with that situation. But the ICC, in the words of the prosecutor, follows the crimes. They see where the evidence takes them. So I'll stop there. As I said, the statute has all these provisions.
It was interesting what you said about the modern effort to have a convention to get countries to abide by the Nuremberg principles, because I think most people, including academics, are under the impression that when the UN adopted the Nuremberg resolution or the declaration on the judgment and principles from Nuremberg in 1946, that that was a worldwide adoption of the Nuremberg principles. And what they don't recognize is that the International Law Commission subsequently enumerated the principles that you just described, and that there has not been another instrument that endorsed those principles since their enumeration. So I applaud that effort, and I'm glad you brought that up. Let me throw at you another quote from Jackson's wonderful opening statement at Nuremberg. Here's the quote. "The Charter recognizes that one who has committed criminal acts may not take refuge in superior orders, nor in the doctrine that his crimes were acts of states. These twin principles working together have heretofore resulted in immunity for practically everyone concerned in the really great crimes against peace, against mankind. Those in lower ranks were protected against liability by the orders of the superiors. Those superiors were protected because their orders were called acts of state. Under the Charter, no defense based on either of these doctrines can be entertained here." So, Navi, how has the Nuremberg precedent affected the defenses of following superior orders and act of state in modern times?
These two principles are hugely important, and they're so progressive. It's wonderful that they included them at that time. I imagine it would have taken a lot of courage, because by then, states actors always thought they were exempt, that their acts, the superior officers' acts, were actually acts of the state. And of course, subordinates always said, especially in the military, that they were following orders, and if they did not follow the orders, they would be court-martialed. So there's that again. In that climate, they came out with closing this loophole so that individuals would not be able to escape justice by saying I acted on orders, or I acted for the state in giving these orders. So this superior subordinate liability is very clearly spelled out in the Rome Statute for the ICC. We had it in the ad hoc statutes where the Security Council put that in there. They did not use the language of command responsibility, which is the military language. They used this language of superiors and subordinates. And this is why in the Rwanda Tribunal, we were able to put on trial the interim prime minister, the ministers of defense, justice, and all these leaders. And they could not raise this argument that they were servants of the state. Now, together with those who take orders, the Rome Statute has come out with the safeguards for all this. So it doesn't mean just because you were a superior officer, you are automatically liable. No, you have to have had some knowledge. You have to have some knowledge that it was wrong. You ought to show that you took steps to prevent it. Now, similarly with subordinate responsibility, there are checks and safeguards. So these provisions are Article 27 of the Rome Statute. That's irrelevance of official capacity. Article 28, responsibility of commanders and other superiors, and Article 33, subordinates are liable unless the legal obligation to obey was lawful and not unlawful. So these are some of the checks and balances. Let me say that, that it has caused huge controversy, dragging the ICC in, because many states support the principle of immunity for heads of state, and they give that as the reason why they haven't ratified the Rome Statute. And even now, they're trying to get out of that principle, including my country, South Africa, has a draft bill before Parliament to add that provision in the national laws to allow for immunity, well, not only for head of state, but for all senior managers. So here again, we are politicians trying the best to look after themselves. If I have a second, I want to say my own experience as an appeals judge on the ICC, and that is the first case was that the pre-trial chamber ruled that an indictment could only be issued against Thomas Lubango Diallo because he was the #1 Congolese warlord, and they refused the prosecutor's application to have the indictment confirmed against the #2 Bosco Ntaganda. And their reasoning was you can only go for the most responsible. Now, I know Bill Shabazz criticized that judgment, but what Bill didn't know is that the appeals chamber overruled that. Unfortunately, the order was under protection for a very long time. So I hope Bill has picked that up because I feel very pleased in my participation in that matter. So we said in some of our arguments, for instance, does that mean that only Hitler could have been charged in the Nuremberg courts? So if you followed the pre-trial chamber's reasoning, that would have been the outcome. So there are very, very interesting dimensions to the superior and subordinate responsibilities. Thank you.
So Judge Pillay, one last question for you. You know, many people have attributed a quote to Robert Jackson that I learned recently from discussion with the panelists before this program, that this quote never actually was included in his opening statement. And I guess in semiotic terms, it has nonetheless become part of Jackson's legacy. Here's the quote. And remember, this is not actually from his statement, but everybody thinks it is. Quote, "We must never forget that the record on which we judge these defendants is the record on which history will judge us tomorrow. To pass these defendants a poisoned chalice is to put it to our lips as well." So let me ask you, Judge, have the modern international tribunals done a good job of heeding this warning, whether or not Jackson said it or it was improperly attributed to him? It's out there. Are there areas in which you think that the tribunals can improve in the rights of the defense?
Whether he said it or not, you're quite right. There is the concern that you have to have due process, fair trials, you have to be impartial, you can't predetermine. As Mike said, is somebody going to draw the list of people to be executed? This was part of the discussion during the London discussions. A lot has been done to ensure fair trial for defense, but I've heard defense arguments, obviously. And they say, for instance, they're not treated as the fourth pillar. You know, the courts are always treated as the judges, as a third pillar. Judges and prosecution. The defense should be an equal pillar. And I think they're right there. They're always given a subordinate role. They really have to struggle. Now, let me look at the situation in Rwanda. Firstly, both the ICTY and ICTR were emboldened to the government in power. So there they were victors of the conflicts, sitting in government, and we had to rely on their cooperation, whether they will send us witnesses, whether they'll hold back witnesses from defense, will they to freely investigate in their territories. I think there's still many, many challenges bringing down this victor justice phenomenon even today, that it's very, very difficult. For instance, the prosecutor could not pursue those Kenya indictments because the indictees were now head and deputy head of state. How do you investigate matters like that? I'm aware that in the Rwanda tribunal, the RPF, the soldiers of the present President Kagame of Rwanda, were never investigated. And there were huge calls about that. Defense would say to us judges, why hasn't there ever been an investigation of who shot down the plane of carrying the Hutu president Habyarimana? And that's right, big gap there. It has not been addressed. And I think we should continue to ask these questions about whether there is a proper representation of defense concerns over these tribunals. And the prosecutor's concerns that they have to necessarily depend on cooperation of governments, some of whose
Okay, so I promised the audience that at 10:45 we'd start doing Q&A, and we do have 10 questions on the queue, but Klaus Rackwitz, you've been very patient, so I have two questions for you, and we'll try to get these done by 10:45. The first question is, the landscape after 1945 has changed dramatically. Non-state actors, crimes of terrorism, cybercrime, environmental crimes, and other new phenomena are emerging. What is the contemporary relevance of the Nuremberg trials and the Nuremberg principles that we've been discussing?
Well, first, let me thank all of you for an interesting discussion. It was easy to wait because I was listening into a very interesting debate. Well, the Nuremberg principle the Nuremberg principles have fundamentally changed the situation by really establishing the principle of universal jurisdiction for crimes of a certain magnitude. And not only for a particular situation, not only in one situation, not only after a particular war, but as a general principle. And I think this strength, this goes on. We would not have these phenomena which we have discussed and touched upon a couple of times without the Nuremberg principles. And I do believe that those principles are strong enough to also cope with what we see today. And the Nuremberg principles were drafted, non-state actors did not exist. Violence came from the states, come from the armies of the states, but terrorist groups that killed thousands and thousands of people were completely unknown. This is a phenomenon that only arose later. But I think that the principle of universal jurisdiction for these crimes could also cover terrorism if there would be a desire to do so. And this is why it's so important that we are not only thinking about the principles, but also about the underlying law to which these principles refer. The Geneva Conventions, they need to cover all kinds of modern weapons. The Crimes Against Humanity Convention that is worked on at the moment is super important and very important, because that is an opportunity to define actually modern, in emphasis, crimes against humanity that were not thinkable maybe a couple of years ago. Nobody thought about a cyber attack that brings down the entire freshwater supply for a whole population. Now, these scenarios exist, and of course, outside of a war, these must be labeled as crimes against humanity. Widespread pollution is another example, and the principles would actually, not stand in the way of that, on the contrary, because they make clear that A, there is a principle of universal jurisdiction for that, B, don't come with the nulla pena sine lege argument, and don't come with the argument, oh, sorry, I was ordered to do so. That is something that will endure, and that is something that actually paves the path also for international tackling of crime phenomena, which by nature are cross-border crimes these days. They are not confined to a particular region or a particular territory, but the principles would actually form a basis to tackle them.
So Klaus, we're starting to get all these questions in. Let me ask the first question of you. This is from Donna. It says, what was the German view of the trials at the time? Did the Germans view it as fair or revenge?
Well, I don't think they took it as a kind of revenge. There was, of course, this argument of this being victor's justice, and there was actually also a little bit of an adversarial position there. But in general, people knew that particular those of the IMT trials were getting what they deserved. And that was actually pointing out what their responsibility was. The problem started later. The problem started when Germany, after Control Law number 13, started to organize war crimes trials and trials against Nazi persons, not leaders, but persons, where ordinary platoon soldiers were targeted. We just had an example in Germany. A 96-year-old former guard in the Stutthof concentration camp was convicted. And of course, he said, I was 17 years old. It was the last year of the war. If I would have said no, they would have just executed me and put me behind the fence that I was guarding. And the judge, maybe barely 40 years old, made quite forthcoming statements about he should have known that this is not allowed, and that causes, of course, a lot of resistance and a lot of feelings. Are these people knowing what they're doing? So the more the cases targeted the low-ranking people, and that is something we could see in the Majdanek trial in Düsseldorf as well, that lasted for 6 years and was a very complicated trial, that none of the persons tried in the Majdanek trial had any command responsibility. They were just guards who behaved horribly, that's for sure. But that caused a little bit of an uneasy feeling, because that could have been your neighbor. Adolf Hitler and Eichmann and Göring and Bormann never could have been your neighbors. But the guy who was convicted maybe has been your neighbor for many, many years. And that left a little bit of a feeling, this is now not taking revenge, but actually targeting people, targeting wrong ones. That leaves a feeling of dissatisfaction.
Klaus, it's my impression that things really started to change in terms of public opinion in Germany in the 1960s, when the German prosecution and courts themselves started to trying the concentration camp commanders. And then after that, the opinion polls started to turn on, you know, the whole history of Nazism. Does that suggest that, you know, the International Criminal Court is right to be based on complementarity, that domestic courts and trials are better when they're possible than an international trial?
Well, they're a very important alternative to avoid any impunity. And that is certainly a gap that territorial domestic systems can fill. The German experience, as I said, is a little bit of a mixed one. There were more than 5,000 people convicted in German domestic trials. It was quite a lot. It wasn't just one or two. It was quite widespread. And yes, the infrastructure is there, and many countries would actually be in a position under the principle of universal jurisdiction to now investigate and also prosecute those crimes. The German Federal Prosecution Office, for example, is currently conducting more than 100 investigations into all kinds of situations. They have grown from a small department into a large area with separation for territorial regions. So this is something that we see increasingly, and it is, of course, also a consequence of the Nuremberg principles, and that's where they live on, although never been formally adopted. And there is consensus about that. There is praise, actually, for the prosecutor to bring on a case against the Syrian alleged perpetrator at the Koblenz court in Germany. There is no dispute about that, and nobody says, well, we could use that money for other purposes. So far, there has been indeed a large consensus that that's the right way to do, if there is no international entity taking care of that.
So this question by Amina says, hello there. Thank you for organizing this event. I have a question for Ben Ferencz. So Ben, this one's for you. It says, why did Ben Ferencz rely on universal jurisdiction in the Einsatzgruppen case and in other cases at the war crimes, the Control Council Law number 10 courts? What was Ben Ferencz's inspiration? Did he see it as a legal principle at the time? And that's from Amina. Ben, can you give us some insights onto?
Very well, very easily. I know exactly what motivated me. I didn't rely on universal jurisdiction, on principles which were that vague. I relied on the fact that these are human beings and you are killing and you are murdering little children. And it cannot be by any conception that you can murder 33,000 people in Babia, for example, in 2 days, or murder thousands of children one shot at a time and look for justification. It's plain crime against humanity, and it's genocide. I use that as well, and it's plain murder. So I didn't dwell much time on proving or trying to prove that what they did was unacceptable. And to come with later theories to say I was talking about universal jurisdiction, I said we have to deal with this in a way which will protect all people in future, so they can live in peace and human dignity. And that should be the rule of law, which governs everybody. And I did take a step in that direction with the judgment, and I've been following it ever since. And you don't have to say it's a universal jurisdiction to murder little children. What kind of a country or what kind of world are we living in? So even on the crime of aggression, I've dropped it. The United States is never going to accept it. They're going to come with excuses why it should be better than what we have. Call it crime against humanity. We have to think in human terms and in planetary terms, and not so much in individual terms as the sole way of dealing with these problems.
Thank you, Ben. This next question is from Craig Jackson. I don't know if he has any relationship to Robert Jackson, but it says, head of state immunity remains a controversial issue among parties to the International Criminal Court. I would like the panel to comment on the legal and practical aspects of that issue. And maybe we should start with Layla Sadat, because in your draft statute for a convention on crimes against humanity, that was one of the issues of controversy.
Thank you so much, Michael. And I should say I'm a co-author. There were 7 distinguished members of our steering committee, including the late Sharif Bassiouni and Bill Shabas, who's on the call. Head of state immunity in some ways is the most, the absence of head of state immunity, right? That heads of state should not be immune from the commission of atrocity crimes. In some ways is the most simple concept, right? Which is that no one is above the law, not even a head of state, particularly with respect to one of these universal jurisdiction crimes. And yet we have literally books and books and books, PhD theses and articles written about it. And I think at the most simple level, it's because people in power don't like limits, right? If you're a head of state, you don't want to have to be responsible. There are legitimate concerns, obviously, about the legitimacy of the court, making sure it's not a politically motivated prosecution, et cetera. But none of these concerns have really been at issue in the kinds of courts with the kinds of judges. I wish Judge Pillay was still visible, but I think she's still on, that are trying these cases. And remember, this was the US argument essentially after World War I, is that a head of state is immune, except to his or her own people. It would have been his at the time. And that is really just through a political process. I think one of the things that's concerning is we're seeing arguments in favor of head of state immunity being advanced right now globally by current heads of state, including the United States president, including leaders of other countries. And the simple principle of Nuremberg, not to get into too many of the details, is that no one is actually above the law, and that a court of competent jurisdiction, appropriately established, has the right to try universal jurisdiction crimes, the core crimes, crimes against humanity, war crimes, aggression, and genocide, even if it is an individual of great power who commanded the crimes to be committed or who is just a head of government or other official. That's not true in national courts, right? National courts, there are more limits because they are operating on a horizontal basis. And while a head of state is still sitting, international law suggests that the head of state might be immune, but the International Criminal Court statute removes that immunity, and our draft did as well, although we agreed at the time. I think that that was a fairly bold statement of the law. Thank you.
Mark, do you want to chime in on that? Mark Ellis? You're on mute.
Sorry, thanks, Mike. Yeah, well, Leila had just answered absolutely the way I was going to answer. And I was just going to add, because sitting here in London, I think about the Pinochet case, which was such an important case in regards to head of state immunity in relation to at least the crime of torture. And so I think there are obviously under customary international law still restrictions, there's still protections for heads of state. But I do think that this is a shift, and it is shifting in the ICC, the Rome Statute, with ensuring that there is no state immunity is so significant. And I think this will continue to develop along with the command responsibility aspect of this. So when you look at whether it's Milosevic, Karadzic, Taylor, all of them had been connected to this important concept of command responsibility, which also emphasizes the fact it doesn't matter what your position is, you can be held accountable, and you should be held accountable.
And, you know, David Crane and Jim Johnson were the first since Nuremberg to try a head of state. Do you guys want to jump in? Dave, just unmute.
Indeed, we had this bright, glowing ember as we're kicking this idea around called prosecutor versus Taylor, which in my mind forever put a large crack in the wall of head of state immunity, which basically says that if you're a head of state and you commit international crimes, you're subject to trial. And prosecutor versus Taylor, that prosecutor being me, who indicted him and took him down, I think is a cornerstone by which we will, and from now on, hold heads of state liable for what they do to their own citizens, referring back to the horrible 20th century. So we made a huge step forward in the age of accountability by forever cracking that terrible wall of head of state immunity with prosecutor versus Taylor. Jim?
Jim just texted me that you covered it. So I noticed that we're at 3 minutes before the end of our program, and so I need to start wrapping things up. Let me begin with a huge thank you to our panelists, the venerable and wonderful Ben Ferencz, and then our final panelists, David Crane, Jim Johnson, Leila Sadat, Mark Ellis, Bill Shabas, Navi Pillay, and Klaus Rackwitz. I mean, this was really fantastic. I want to invite everybody to a program that we're going to have in London that we were going to have today, live, but instead we had to do this virtually because of the coronavirus. Next year, on this date, we're going to be in London. We're going to celebrate the anniversary of the London Charter and the Nuremberg Tribunal, and we're going to bring all these people back, and we're going to have 2 full days of panels, and it's going to be fantastic. So look out for information about that. And then I want to send this back to Kristan McMahon so she can wrap things up from the Jackson Center. Kristan?
Thank you so very much, Michael. On behalf of all of our panelists, we appreciate your attention and your questions today. As Michael said, we look forward to seeing you in London next year on this date when we celebrate the 75th +1 anniversary of the London Agreement and Charter with the International Humanitarian Law Roundtable. So thank you very much for joining us on our journey today from London to Nuremberg to the present, and we look forward to seeing you all soon. Thank you.